That being said, I will turn it over to our host tonight, Carla Zednik-Seiser. Go ahead, Carla.
Thank you, Dave. Good evening, everyone. As Dave said, I am Carla Zednik-Seiser. As many of you know, I am both an advisor as well as the president of ClearStep Financial. We're educational oriented. We have, many of us have clients all over the United States. We have offices in Wisconsin as well as Minnesota. I also would like to welcome you to tonight's estate planning presentation. So we do these webinars throughout the year for educational purposes. We're very excited and happy to have Nathan Eckley with us. Our goal at ClearStep Financial is to help educate and guide our clients through our ever-changing world. And to help accomplish this tonight, as a goal, we are pleased to introduce our guest speaker, Nathan Eckley, an attorney and partner with the Affeldt Law Offices. And I believe you will find Nathan's presentation educational, informative, and enlightening. So may I welcome Nathan. Thank you, Nathan, for being here tonight.
Thanks, Carla. I just want to make sure everybody can hear me both here and then online. Carla, can you hear me?
Yes.
Okay.
Yes, great. Thank you.
All right, then I'm going to get started. So I want to introduce myself. The easiest thing for me to say is, well, I'm a husband, father of 6 children, a Missouri farm kid who went to Chicago for law school and then wound up here raising his kids right next door to his in-laws in Brookfield, Wisconsin. So all things I did not plan to do when I was sitting on a tractor many, many years ago, thinking about what do I want to be when I grow up. But important to me is that, yes, I have a lot of background in experience in estate planning, but I'm a regular person. The best title I have is hardworking farm kid. That's it. I just happen to have a law license on top of it. I am dual licensed. I'm licensed in Illinois, where I began my practice in the Chicago legal environment. And then I transferred here when my wife said, we're leaving so we can go raise a family, and we're going to Wisconsin. I said, great, just show me the door. I want to talk to you about what's inspired me to present tonight. And it's part of the family, especially just having done a wonderful Father's Day. I'm going to introduce you to my family and how that ties into my estate planning tonight. So tonight we're going to talk about beneficiary planning, wills and trusts, and powers of attorney. In order to talk about that, you need to meet my 5th child. This is Micah, and this is Micah at about 2 years old. And we all know that in life mistakes can happen, but one of the things that we want to try and work on in the estate planning realm is how do we avoid the mistakes? The first thing is do things like this, educate yourself so that you're ready to take on some of the decision making you need to put together an estate plan. What you don't know about Micah here is that his mistake was taking a Hot Wheel and chucking it at his older brother and hitting him square in the face. And I just happened to catch it on my phone at the same time, not thinking he was going to do that. So I thought his mistake was in throwing a Hot Wheel at his older brother, and he thought his mistake was getting caught. But really, the mistake was it was an ineffective transfer of the Hot Wheel from his hand to his very demanding older brother because they didn't know how to effectuate the transfer. And that's really what part of this talk about tonight is the effective transfer of your assets between, especially if you're couples, between the two of you, if you're a single person or you're transferring assets to that next generation. Well, what's the effective way to do that? So we need to talk about the ways that you can distribute assets and the typical types of distribution documents. So generally speaking, the way you can transfer an asset is you can jointly own it with someone else. And so you hope that there's an automatic ability to transfer it. You might name someone as a beneficiary or some group of someone's as a beneficiary. Another very effective tool for transferring assets as part of your overall estate planning. You might also use a will or a trust. For joint ownership, this is a pretty easy example. Joint ownership would often be held in title as a joint tenant. So for anyone who's a spouse here tonight, maybe we own our house or maybe we own our car with our spouse, and so therefore we own them jointly. Well, hopefully you're a joint tenant with an automatic right of survivorship. If you own something jointly with someone else, especially your spouse, you hope that you receive the whole thing if your spouse predeceases you. But sometimes we own things differently. They're called tenant in common. So I like to use myself as an example in all of my estate planning. So my brother and I were tenant and common owners of a piece of real estate, a piece of Scrabble ground farm ground in Missouri that we had inherited from one of our relatives. Two brothers have great ideas, but very rarely are they the same idea. And my brother and I, who love each other dearly, are no different. We both had thoughts about what we wanted to do with that farmland, knowing that I wanted to do something and I wanted to profit, and he wanted to do something and he wanted to pass it on to other family members. Because we couldn't, it wasn't worth a long drawn out Hatfield and McCoy type of battle over the asset. So we just sold it, knowing we couldn't own it together because we didn't have the same plan. We just sold it to someone else. It actually was another family member, so it honored my brother. I got the money that I could get while I could get it because that was what was important to me. But know that how you own it can affect it, because we both knew, and I made sure to tell my brother, just understand, I'm not planning to give you my half interest. If I'm going to give anything, I'm going to give my half interest to my wife. And I know you love her dearly, but I doubt you want to co-own this piece of farm ground in Missouri with your dead brother's wife. That seems like a bad idea. Important also is, don't forget that we're in a marital property state, so there are certain spousal rights to certain types of assets, even if they're not named. So just talking about how we own things can be the first part of the discussion of how do we transfer things. So what could be the second piece? The second piece is probably something that if your clients here at ClearStep Financial, you have a financial advisor, or you've been looking at these things as you've been acquiring certain assets, you might have beneficiary designations, and whether those are payable on death, POD beneficiary designations, or whether those are transfer on death, TOD beneficiary designations. Importantly, either version pays or transfers directly to the person or persons named that particular type of asset. So it would be very typical to have, for example, life insurance. And again, I use myself. Life insurance for me, it's a lot of term life insurance. My wife is very aware that I'm worth a lot more dead than alive, and yet she lets me continue to stay here. But she knows that she's the primary beneficiary of all that term life insurance. Great. If I happen to predecease her, then she gets the millions of dollars in term life insurance. She's hoping I'll stick around because of those kids. I might need to deal with them when they're done driving their mother nuts. You might have other assets that are very similar, but the important aspect of a beneficiary designation is an automatic transfer through a beneficiary designation for a particular asset means that it's not subject to probate. We're never going to go through the court system in order to effect that transfer. We are going to present, for example, if I die, my wife's going to walk over to our insurance agent and she's going to present the death certificate, point out at the bottom that I didn't kill him, he died on his own, and then she's going to collect the life insurance. And then it's hers to do whatever she wants to with, including hopefully take care of those kids and hopefully never have to go back to work. Yes, sir.
No matter if it's a will or a trust.
Beneficiary designation in Wisconsin law is the controlling intent. I will tell you, sure, there's case law that talks about other intent, but it's not like you scrawl all over the beneficiary designation card for life insurance or a 401k or an annuity about, well, what you might like to happen if something doesn't go the way they predecease you for some reason. We talk about intent, and that's very important in estate planning, but the intention there is they only allow you to put a person or an organization, and that's it. All that other stuff is just not important. You'd have to prove it through other means, and kind of beyond the scope here, but important to me, it's, well, that's controlling first. Whether you have a will or a trust, it doesn't matter. The beneficiary is important because that's where we start that transfer process. I just want a general warning. Beneficiary designations are a wonderful tool. It is one of the tools in the estate planning toolbox. If you use them, make sure it coincides with the overall plan to distribute your assets. Another, for example, I might want to benefit certain children of mine in the future with different assets. And so that might include not 6 equal shares as beneficiaries or contingent beneficiaries of dad's retirement planning, That might include more or less for various different reasons, or it might be all to one of my children because I love them more, or I love someone less. Just if you ask them, they're going to tell you who the favorite is and how they're not and why they should be. Understand that it is your decision, but make sure it coincides with the plan, whatever that plan might be. Beneficiary designations can be used for bank accounts, certificates of deposit, life insurance, very often retirement accounts, sometimes real estate, but you have to record a document to provide that beneficiary designation for real estate, often called a TOD, transfer on death deed, or designation of TOD beneficiary. Those are two different forms that we use here in Wisconsin. Ultimately, the purpose is the same. You need to express your intention on whom you want the real estate to transfer by beneficiary designation, and you must record that document during your lifetime for that to be an effective designation for real estate. Once again, same warning, must coincide with your overall plan to distribute assets. It's very easy for me to talk about easy situations, but I doubt that there are very easy situations sitting in this room or listening live online. Everybody has a wrinkle. Everybody has a story. I very much am comprised of stories. Why? Because I've gotten to interact with a lot of people over the years. Important to me is let's get your story correct when it comes to beneficiary designations and especially the overall plan. Here's what I find are the most common mistakes from beneficiary designations. When your distribution plan is primarily controlled by a will, so through the probate estate, or through a trust, so outside of the probate court, but through a different document, but you beneficiary designate all of the liquid funds, the cash. Well, now the trust owns the house, the probate owns the commercial real estate, but there's no money to pay the bills in the interim. And now you get into some big trouble pretty quickly. So make sure you understand if an asset needs some liquid funds, well, maybe a bank account, a cash account, or certificate of deposit, a life insurance policy is directly payable to your estate or to your trust. Again, my example, my beneficiary designation for my life insurance policy, primary beneficiary, my very lovely wife. But if she were to predecease me, the contingent beneficiary is our joint revocable trust. Why? We have 6 young kids. None of them are of age yet. All of them are minors. So if there's money that needs to pass somewhere because their parents have died, it needs to go through a different vehicle in order to provide for them in our total plan. Every once in a while, I see incorrect beneficiaries named. Be precise, but also be diligent in updating. That's another concern. So being precise could be, hey, I beneficiary designate Bill Smith. Which Bill Smith? You have an uncle, Bill. You've got a cousin, Bill. And you've got, a long distant relative that's also, another cousin, but it's Bill the third over there. Which Bill are we talking about? So make sure you're very precise in how that person is connected to you or provide identifying information. Hopefully, if they're being listed on the beneficiary designation should include their social security number, how the government knows everybody. So this is an identifying information. Understand that sometimes these assets pass with a tax liability, so you have to take that into consideration when adding beneficiaries. Maybe certain assets are okay to beneficiary designate, even if there's a tax liability to certain responsible people, and maybe it's not for certain other irresponsible people who tend to spend every dollar they get, and then when the tax man comes for the tax part of it, they don't have any money. Last thing you want is to leave your beneficiary with an IRS letter and then a visit by an agent. Keep in mind qualified accounts, so things that do have taxable income. That is a big part of your planning, and I definitely recommend talking to your financial advisor about how to beneficiary designate qualified accounts, whether that's a living, breathing human being person. That should be a fairly easy recommendation, or whether or not it should be part of your estate or your trust, so part of another distribution plan. Don't forget your spouse as a beneficiary, because sometimes our spouses aren't our only spouse that we've ever had. And so if we have an intention to benefit children from a different relationship from our current spouse, just understand that has to be part of the overall plan. You got to think about these things. Yes, sir.
So we got one of our sons, they're starting a family, they have a daughter, our granddaughter, but may not be the last one. Can you project a beneficiary for possible future kids?
We talk about then, is it a person or a group of persons? And for beneficiary designations, they're often going to talk about a person. So you're not going to be able to predict who it is. But the intention there is you're going to benefit your son, whether he has no children like my brother, 2 kids like my very responsible sister, or 6 kids like their very irresponsible lawyer brother. So we don't worry about people who are hypothetical, because the hypothetical only makes a difference if we talk about it in these sort of contingent plans. I'm going to let you know your beneficiary designation is not usually going to allow you to just name the kids of my son. You're going to have to talk about who those people are specifically now, which is why you update all the time, which is why I will tell you that not all of my children are specifically named in my documents, because many of them didn't exist at the time. When I make references, I don't talk about how many years ago. I tell you how many kids ago that was for me. And so for me, it's that was 3 kids ago, so I'm never going to remember that. Hey, that was 2 kids ago, so I have a vague recollection of you, but I can't remember. You must be one of my kids' friends. I don't remember. And then literally, I met a kid one weekend. The next weekend, I see him getting a haircut, and I'm like, hey, how are you, sir? And he goes, I have no idea who you are. That's perfect. Walk away then. I'm a stranger. So don't worry about that, but talk to your planner and talk to your financial advisor about what you can and can't do with beneficiary designations. And my hope is that your son is not done.
Hey,
As a
Nathan?
big family man. Yes, ma'am.
Nathan, would you be able to reiterate the question, number 1, because we can't hear
Oh,
it?
I'm so sorry.
That's okay. And number 2, would you be able to, so we do, and I know a lot of the laws, whether it's Wisconsin, Minnesota, or some other states, because we have people in other states too, they're generally similar. They're generally the same, right? And then number 3, I know one thing that we do with children under the age of 18, we usually designate a custodian for a beneficiary for the benefit of the children listed under the Uniform Transfer to Minors Account Act of either Wisconsin, Minnesota, or wherever else. For children who are minors, then they have a custodian as the beneficiary.
That's correct. So let me reiterate the question. The question was naming contingent beneficiaries for a group of people that don't exist yet. So potentially future grandkids. So that's the first question. Normally, you would update your beneficiary designations as you're going along to keep that in mind. It'd be very difficult to plan for people who we don't know if they are ever going to exist. I would stress, yes, what Carla has said is very important. If you're thinking about naming anybody who's a beneficiary and a specific beneficiary, and they're a minor, it would be common practice if you have a beneficiary to talk about a custodian for those account holders. Why? You want to make sure the person that you trust to handle those funds for a young person can do that. Here in Wisconsin, a Uniform Transfer to Minors Act custodial account, if you name the custodian, you can also delay the distribution, not just 18 years of age, you can delay it to 21. Understand at that point, though, those funds belong to the beneficiary. Custodian steps out of the way, or is supposed to step out of the way, and hand those funds over. Carla, did that cover the other issues that you've discussed?
Yes, thank you.
You're very welcome. But again, important to me is keeping up to date on those beneficiary designations. You might want to use a will. And I know you probably have heard a lot of, different conversations, cocktail talk, maybe ads on the radios about wills and trust. I'm not here to demystify or to tell you the exact answer as to what's right for you, because everybody has a specific plan. But here are some reasons why you might want to use a will as your distribution document. So it controls assets that are individually owned at the time that you pass away. So things in your own name. It's also those assets are then controlled by a personal representative, what we used to call an executor or an executrix, and that's actually what Illinois still uses the term. But who's the person who is the authority figure in the will? The personal representative. It is subject to the probate court's jurisdiction, meaning there is court supervision and oversight of some kind in that process. It's limited in many cases because we don't need a judicial officer standing over the shoulder of the person that we trust to distribute these assets. But every once in a while, an issue comes up that does need the court to be involved in. And it also avoids intestate laws. So when you draft a will, your will is designed to tell us the specific instructions of who gets what and how they receive it. If you don't write those things down, you never create it. The intestacy laws are the default rules. So for example, my parents might want to disinherit their black sheep son who ran off the farm and went to go, have children in the cold north of Wisconsin. Well, they're going to need to write that down because even in Missouri, the default rules would say divide everything equally between those siblings after my parents pass away. It's very easy for me to say I don't want a tractor. I want none of the livestock. I don't want any of the headaches that come along. It's the reason I left the farm, so I don't want any of that back. So my hope is it does exclude Nathan. Everybody can have all the other stuff. I don't want any of it. My brother farms and lives with my parents. He never married, no kids. So this is all he ever wanted to do. So he's doing exactly what he wants to do. So he really should have everything. And my sister lives 10 minutes away. And so she should have whatever's left over because they're the ones who are taking care of our parents. So they should get whatever they have, including all of the chickens and the goats and the sheep and the cows and everything that Nathan doesn't want. But I want to avoid the intestacy laws. I don't want an equal share of those things. And I want to make sure if my clients have a specific plan, it's to avoid those default rules because those are just guesses. Those are guesses by legislatures who decide to come up with, well, here's what we think is best. If you've ever disagreed with a legislator, the last time you want to disagree with them is after you die. So write it down. Some things to consider when we're drafting a will for a client. Remember what assets are subject to the will's distribution plan. We had already talked about things that are jointly owned that potentially pass to other people. We've talked about beneficiary designations that might pass. So those things are going to pass outside of the will process. So you have to sit down and think with your planner, with your advisor, what things will pass pursuant to the will and what things will pass non-probate outside of that system. Who do you trust? You won't be able to see this very well, but I always use this example when I talk about people and their money. It's like handing your wallet or your checkbook or your purse or your car keys or whatever. When you're handing that over to somebody, that's not everybody. You don't trust everybody in the world to handle this. And I know this is being recorded, so my kids will be able to watch it later, but they already know this. My 6 kids, I've got the 3 older ones and the 3 younger ones. Well, I would never trust my 3 little ones. They're 6, 4, and 2. They're just not ready to handle any of this stuff because I know what we're getting. A bunch of Twizzlers and like silly string, but we're not getting what was on the grocery list. And honestly, it's not all of my older children. Some are just better at dealing with things than others are, and some are just, more capable. It's, hey, well, I understand that. So understand that the person that you want to handle this, be a personal representative, to go to court or to hire a lawyer to go to court or to help assist in the transfer of these assets through the probate process, they need to have at least a basic understanding of that fiduciary obligation. It's very important. When you're thinking about also what to is part of your will distribution plan, remember we're dealing with personal property potentially. So things that are easy to move, pick up, a phone, your clothing, those kinds of things, but don't have a lot of real world value. And then the residue, which is everything else. And so that's usually the big ticket monetary items. So keep that in mind. You might also have special provisions. And in fact, Carla hit on one here that we tend to put in all of our basic will planning for people who we don't know who those potential future group of people are. But in any event, if we think that there's ever going to be someone who is under a certain age and they meet the qualifications for a uniform transfer to minors account, so a custodial account for their benefit, that default language goes into our standard will for most of our clients. We never want people who are not ready to have money to have it, and then we want to give them the rules as to how that they're ever going to get it and who's going to be in charge. Note, if you're a married couple, usually if you have a married couple plan, we wouldn't have a probate when the first spouse dies, because often things transfer automatically to the surviving spouse, either as joint owner with right of survivorship or as the primary beneficiary. So there's very often the case that things are going to pass directly to the surviving spouse. It's when the second spouse passes that we'll be dealing with, well, what's the will say now? Common myths about wills. It distributes all of my assets. Well, we've already talked about things that avoid that probate process, so consider that. My personal representative is in charge immediately after I die. No. Your will, in order for it to be effective, needs to be confirmed by the probate court. So just because I get this phone call all the time, mom died, I'm the named personal representative, I'm in charge. No, you're not. The court hasn't approved you yet, and we have to go through a process to confirm that you're the right person to do the job and that the document's valid. You have to wait. So that means that there's no authority. I often have this scenario of, well, I just started to divide things up in the house, and I got an estate sale, and I've got the property listed with a broker. Have you gone to court yet? No. You should stop doing all of those things because you have zero authority to do any of it. And then it resolves conflict between beneficiaries. Wills don't do that. You think, well, I wrote it down and the lawyer wrote it down too, and so that's going to resolve all problems. It does not, but it is a good evidence of what you would like to do. It also doesn't resolve conflicts between non-beneficiaries. So my in-laws live right next door to me, and I love them dearly, but I am an outlaw, and they know it. He's that crazy farm kid that is going to do whatever his wife says as long as he's okay, and then he's going to put his foot in the ground and he's going to be grumpy about something. So we have a wonderful relationship where my wife sets the rules. I don't have to do anything. I do what I'm told when I need to, and then when I don't, I just walk away, and she goes to go talk and set the rules again. It's not my job to tell my in-laws what they should or should not do with their stuff. They have two very capable kids. My job is to mow the grass. That's pretty much it. That's all I really ever want to do. Just know it's not, non-beneficiaries often are there whispering in the ears of their spouse or their significant others, or they're the ex-spouse saying what they should or should not get from a deceased parent's estate. Just understand that writing it down is helpful. It doesn't necessarily resolve all conflicts, so keep that in mind. Sometimes you might need to use specific language. I would hope if my parents disinherit me to make sure I don't get any of those cows or chickens or tractors, that they specifically write, because he doesn't need any of those things in suburban Wisconsin, which is correct. I'm going to spend just a little bit of time talking about the final document, but it could consume an entire program all by itself, which is called a trust agreement. When I'm talking about a trust agreement here, I'm talking about a revocable trust. So something that's easy to fix, easy to deal with. It's yours. You can change it however you want to. You can completely get rid of it if you don't like it. Understand that a trust agreement only controls the assets titled to the trust. So in my Hot Wheels example, well, a trust is really everything inside the car, everything that's inside there. And who's in charge? Well, the assets are controlled by the trustee. That's the driver of the car. But outside of the car, there might be other things. Outside of the trust, there might be other things. They might be added later. Like in my example, life insurance to a spouse, but if she predeceases me, then to the trust. That's a possibility. But it might also never go into the trust. I might end up someday, hopefully, knock on wood, I'd love to see my kids grow up, and I hope that I can make them direct beneficiaries. I doubt I'll be the surviving spouse, but I might be. It's possible. I want to make sure, hey, I'm going to use up all your mother and I's money, and you six can have the dollar that's left over, but I'm going to give it to you as beneficiaries directly, because my hope is they're all adults by that time. Trust, not subject to probate, meaning we don't have to go through the court supervision process because we don't believe that we need it. And in most families understand that that's very typical. My view of the world is skewed because my phone rings when it's not puppies and rainbows at the other end, because that is my job. My job is to deal with conflict and to find conflict resolution. So that means I don't understand when things go right, because nobody ever calls their lawyers when things go right to give me a pat on the back. It's like being a parent sometimes. No one pats you on the back for, well, they turned out pretty good. It just happens. Well, great. but understand that it's not meant to be part of that process. Great. You don't need to call a lawyer about it often. It can be used both before death and after death. Remember, if you have a trust, typically you're adding assets of your own into the trust car at that point, but they're still for your benefit because you're either the driver or you're riding shotgun because your spouse is the driver. It's not just for the 1%. It's used for a lot of people for a lot of different reasons. It can be for specific reasons, for specific types of beneficiaries. So just keep that in mind. When we talk about all the tools of estate planning, there are lots of different ways to effectively transfer assets from one person to another or to a group of people. And it's finding the right mix blend that works for you. And that's a very specific process. So you need to talk to your advisor, talk to your lawyer to find out what the right process is. Wait, Nathan, I'm still alive. Why are you talking about when I'm dead all the time? Well, understand that that's usually the conversation that I have with my clients, but we can't forget that there are other estate planning documents that are part of the plan meant to help you out when you're alive, but unable to do things for yourself. And so that could be powers of attorney or living wills. And I want to take just a quick time out and just talk about living wills. I do not make a separate slide about it because a living will is a misnomer. It has a bad name and I don't like it. It's because most people think a living will is actually their will when they die, and it is not. A living will is a statement of your intentions if you're ever in a terminal condition or you're in a persistent vegetative state, so you're still alive. Living will, yes, you're still alive, but you can't speak or communicate your wishes at that point. So that's a statement of desires and wishes. It tells nothing about what to do with your assets. So just understand it's got an interesting name, but this lawyer doesn't like the name. It's meant for something else. So that's why we're going to talk more about the powers of attorney. Who would you pick to take care of your decision-making if you're still alive but unable to do it? And there's two kinds of powers of attorney. A durable power of attorney is often for your finances and property, and a healthcare power of attorney is for your healthcare decisions. Let's start with the financial power of attorney, the durable power of attorney. Here's where a principal is authorizing someone who's become typically incapacitated or incompetent to make important financial decisions, okay? It can occur before then. For example, my wife and I have financial powers of attorney that allow her to act for me and me to act for her, whether or not we're incapacitated or not. And the reason is my wife is a very savvy refinancer of our house. I would often come home as rates were dropping back when money was cheap, and there'd be a strange man in my living room. And I would say, "Who are you?" And it would be, "Well, I'm so-and-so. I'm your mortgage broker." "Oh, that's nice. What are we doing today?" "We're refinancing your house." "Oh, I didn't even know that." "What are we doing, hon?" "We're going to save." And she'd run through the whole spiel because she's all about spreadsheets and tables and tell me how long before we made our money back. "Great. Where do I sign?" After about the third strange man in my house, I said, "Okay, just do it whenever. You don't have to wait for me. Just, you're my financial power of attorney. Please do not surprise me." So I'll just keep working. Understand that this is who you're asking to handle those big financial decisions, important things like paying bills. And it's typically in most client scenarios, it's when they can't do it themselves. So when they're incapacitated or incompetent. So you, the principal, are trying to avoid guardianship court. Going to court to appoint somebody to take care of your decision-making, especially your financial decision-making, is a very ineffective way to deal with your assets. Probably going to spend thousands of dollars to probably still have the court appoint the person that you could have just written into that financial power of attorney on your own. You can name anyone you want to act as your attorney in fact. So your stand-in person, it's very typically a spouse. It could be children. It could be a sibling. It could be friends. Just again, understand that the thing you're doing is I'm handing over my checkbook during my lifetime, and I've got to absolutely trust the person to do that job. If you do not absolutely trust the person to do this job, you will not name them in a financial power of attorney. They're just not ready for it. You have to be of sound mind when you're executing a power of attorney, meaning you have to understand what you're doing. And the power of attorney can be effective when it's executed. That is very typical. Hey, it's effective right now. or it can be triggered by an event like incapacitation. Hey, it's not effective until doctors determine that I'm incapacitated. Incapacitation can be determined by a licensed physician or psychologist, typically 2 here in Wisconsin, or an attorney at law. I'm going to tell you that I'm a pretty good judge of balls and strikes when it comes to people's capacity because I got 20 plus years of experience, but that's not perfect. I've seen people who probably shouldn't be signing legal documents sound pretty good on the stand before. Why? They can put it together for a few minutes. So I don't know that I would ever want a lawyer just to be the one to decide that. A judge could decide that, and oftentimes that's good. Judges are good measures of humans, or an appropriate governmental official. And I don't know who that is, but I do not trust that at all. So that language is buried in the statute, but I don't trust many governmental officials to do anything other than to take my tax checks. Yes, ma'am.
Your power of attorney be a beneficiary?
The question is, can your financial power of attorney be a beneficiary in your other planning documents? Yes. You have to make sure that them being a beneficiary doesn't affect their ability to make sound financial decisions for you, though. And it would be very typical in my office to not allow a beneficiary to change beneficiary designations. Only you can change your beneficiary designations. We usually don't let agents who are beneficiaries change beneficiary designations. You'd have to give me a really good reason why you want to allow that to happen. Because again, I get the bad phone calls. My sister took my mom to the bank. She signed a financial power of attorney and it allows her to change beneficiaries. And now all of the beneficiaries for everything 100% is the sister.
So you have state that POA can actually.
You decide what level of authority that they have, and the question is, how do you make sure that you get in the right authority? You go through that document and you make sure it says the things they can do and the things they can't do. Yes,
Can you
sir.
explain that? Maybe I missed it. Because I've been both power of attorney and now I'm durable power of attorney, and it means a lot.
So
different.
durable just means it's effective no matter when. Just think about that. But typically we're talking about a durable power of attorney when someone has become incapacitated, when someone is under some kind of limitation in their decision making. So I like to use the term limited power of attorney. I'm limited to do things in certain scenarios versus durable is almost unlimited. Hey, I have full power because someone else can't do things for themselves. So when I'm sure you feel like there's a big distinction, for me, it's tell me what you can and can't do right now. And so very often financial powers of attorney in my office, you're a durable power of attorney because we will specifically state this applies now when you have the capacity to tell this person what they can and cannot do verbally, or later when you lose the capacity to do it. It is durable no matter what the situation is. Okay. Yes, ma'am.
Question. So if this is my spouse and I have a.
Is he your
durable-
spouse? Okay. Okay.
Don't you have a POA for two of us?
So the
At the
question,
same time?
yeah, so the question would be if we have a spouse and we've named our spouse as our first agent or agent under a power of attorney, can we have either backups or a separate standalone power of attorney for children or other successors at that point? Yes, you can do both. Oftentimes, if they're separate documents, the spousal power of attorney and then the everybody else power of attorney, you will specifically reference that in those documents, meaning, hey, my spouse is my first agent to act and they have full authority to do everything all the time, no matter what. But my kids, they're still subject to my spouse not being able to act, and they may or may not have the same authority, but oftentimes it's only upon a determination of incapacity that you have to be essentially diagnosed with a problem that doesn't allow you to make decisions for yourself. And only then will that kick in. It'll be activated upon that condition. We normally in our office, we don't do the separate powers of attorney. It's just, it's more documents to make it harder. And it also means it's more documents that may or may not be available at the time you need it to happen. So we put everything into one document, but we just put the order. If our spouse can't serve, then we're going to list the person or persons who are the default successor agents at that point. It makes it easier. I do lots of other areas of the law, and I hate real estate transactions, not because I think they're complicated, because I got to look at 17 different pieces of paper in order to find out where we're at in the transaction. Well, that's the last thing I want to do in an estate plan. I want to look at as few documents as possible. My first boss was a KISS method lawyer, and he made sure to tell me, keep it simple, stupid. And he was talking to me because he knew when he hired me out of law school, I knew some stuff, but I was still stupid as to how the law worked and how people interact with the law. And so it was, what's the simplest way to do something? Keep it all in one document if you can. And that would be my recommendation too. So I'm going to switch now to a healthcare power of attorney. Ma'am, did you have a question? Oh,
That to do with this, but it's, I have 2 children, one has special needs.
mhm.
So do you still recommend like, and I am my son,
Mhm.
he's fine, but so do you trust for that, with the child with special?
Well,
needs?
so that's distribution planning. And right now we're talking about powers of attorney. So, but let me back up. So the question is, if I have children that have different needs, what type of planning should I do for those children? And I'm going to tell you, this is the lawyer answer. It depends. I have 6 kids. I have very capable older kids who I think are on a great path. And then I have 3 little boys that I don't know yet. There's a lot there that I don't understand. But I know plenty of my friends. I mean, so I have a friend who has a delayed daughter, same age as my 3rd child, but really interacts better with my younger kids. So because of where she is on her path, and I don't know where her path goes or ends, but I would anticipate that they need to consider that as part of their overall plan, that she may or may not ever be able to be a fully functioning adult. And if she's not, that she'll get treated differently in their planning. And that would be pretty typical. I mean, there are a lot of things that are now known knowns that we didn't know even 40 years ago. And just to date myself, I'm a bicentennial baby. And so I grew up and was born when pig vaccine problems, and my mother was scared to death that she was going to have a special needs child. Well, she did. She just didn't realize it would be a different kind of special need. He's constantly got his brain going all the time. He doesn't know how to shut up. And I need to send him to law school because he's got to go do something different, even though I'm going to miss him. So there's all kinds of things that we know now that we can plan for. But then you got to think about if that person does have an inability to handle their own finances, or maybe they have a limitation, you still want them to be as independent and sort of decision driven on their own, right? I mean, a fair statement. I want my kids to be the best version of themselves. But if they need that extra help, who's the right person to do that? And is it a sibling? Do we want to put a sibling in charge of someone else's stuff? What mom wants to leave them? It's a hard question. It doesn't mean that it's not one that's unanswerable. It does mean that it's one that takes special care when you make the decision. So, and I'll relate it to what we're talking about here. Financial power of attorney is a very objective type of standard. So I would think that's a pretty basic understanding. But the level of financial complexity for most clients these days isn't meant for people that don't understand financial complexity or aren't willing to ask the right questions. You need to have an active advocate if they're going to be your agent under a financial power of attorney. They got to be able to go and walk up to a banker and say things like, I need to go through all of the bank records and figure out, why is my mom missing $17,463? What's going on? Great. Go through the bank records and be adamant about those kinds of things. Same thing. They're going to need to tell a doctor under a healthcare power of attorney if they're acting. I don't understand any of those choices. Bring it down. Help me understand what we're doing here. What, because the doctor is going to obviously be way more educated than they are in that specific area. Well, they need to be able to relate to that or be able to say, I need you to slow it down for me. Okay. So healthcare power of attorney. So we're switching for a second. We were talking about financial power of attorney, durable financial power of attorney. So that's your money when you're alive and unable to do things. But healthcare powers of attorney, I'm alive, but I don't have the ability to tell a doctor or a care provider what I do or don't want to happen to me as a person. So this is very subjective. It's super personal healthcare decisions. So the person creating the power of attorney for healthcare, the principal, is providing instructions to their attorney, in fact, their agent, on what type of care they do or don't want if they become incapacitated. Things like pain relief options, life-sustaining options and procedures, artificial life support removal if no brain activity, organ donation, disposition of your body if the injury causes death. And again, you can list anyone you want to, but this is not everybody under the sun. Communication between the principal and the agent is key. And so you have to have a very uncomfortable conversation with anyone you put in a healthcare financial power of attorney in advance. I'm going to need you to do something difficult, like tell a doctor to stop doing stuff and maybe just allow a natural process to occur at that point. And that might mean I'm going to die, but don't feel guilty. You're not killing me. I already told you I don't want that kind of care. Or it might be the other way. Absolutely not. They need to go to the other ends. They need to find that procedure, or they need to go back in there and figure out what's wrong. They need to do exploratory surgery. I have no idea what it could be, but you've got to get an active advocate involved. When are powers of attorney good? When the principal, when you choose an appropriate decision maker to be your agent, and then the agent follows through on those decisions. So remember, I've got to find someone who is capable of doing the thing, and then I know in an emergency, because that's very typically when we're talking about powers of attorney, and almost always it's a medical emergency. Hey, in the crucible, they are tested, they're fire ready, and they will follow through on those instructions. It's especially great when a principal is a poor decision maker. There are lots of people today who years ago we would have just put them under guardianship, because we would have used an inappropriate term for them and just sort of lumped them together. But they're independent people, and we're trying to give them their independence. But if they're not great about making complex financial decisions, maybe they do need a power of attorney agent to help them to go visit with their financial advisor to make sure that they're picking the right types of, options, investment for their particular situation. But they're not incompetent. Years ago, we would just tell people, they're crazy, they're incompetent, they don't know what they're doing, so we're going to use the court system to basically force them into guardianships. And they didn't need them. The use of guardianships was way overused for many years. And that's not a Wisconsin thing. That is a United States thing. So powers of attorney can be effective tools for those people as well. And it's especially important when healthcare providers and financial institutions are unsure of what you want. Long gone are the days when your local banker knew you when you walked in the door. They just change and revolve, and that's not the way the financial system works. You hope that you'll have a good advisor, like here at ClearStep, who cares about what you're doing and what your goals are. But that's not every place. And you also don't know, your doctors have no clue as to what you really want. Why? Because we avoid talking to them as much as possible. Nobody likes to go to the doctor, so they may not know that, I don't like that type of procedure. I don't want that. I don't want chest compressions if it's a death delaying tactic rather than a life sustaining tactic. So understand that this is to help the professionals fill in the gaps when the agent comes to them. When are powers of attorney and when do they go bad? Financial powers of attorney, I see financial exploitation all the time. It is a rampant problem, but why do I see it? Is because I used to take a lot of court appointments from Milwaukee County, which is its own socioeconomic beast right now. But it's financial exploitation. People are using powers of attorney to steal money, and it's often from their own family members, which is brutal. When you're causing neglect for the principal's care because of cost, when a beneficiary decides, you know what, I need the money worse than mom needs the money, And so they use that money and take it away because mom doesn't really need to go to the nursing home. Mom doesn't really need the high level of care. Mom doesn't need the special person coming into their house to provide support. They can just get by with my cousin who's willing to do it for $10 a day and some snacks kind of stuff. And then there's physical and emotional abuse. Put me in charge of the money or else I'm not going to love you. I'm not going to come. I'm not going to bring you your groceries. I'm not going to take you out to your friends. And I know that you can't get around because you're basically also medically unable. Healthcare powers of attorney. When are they, powers of attorney kind of bad? When the principal has an underlying mental health issue or they vacillate between being decisional and non-decisional, that's difficult. And so, yeah, I mean, I see healthcare powers of attorney go wrong. It doesn't mean don't do it. It means just do it soon and be effective and be thoughtful in your decision-making and what kind of authority you want to give them. And it also doesn't end of life disputes between family members. I will tell you that the healthcare power of attorney, when executed and when it's followed and dealing with an end of life issue, is definitive. It should be definitive, but that's not going to prevent other people from second guessing what their sister or their brother did with mom and dad in those waning hours and days. Just understand that that's why you put someone who's fire tested into that role, because it's a very difficult role. And this is why we plan about these things, because there is no certainty in the world. And those are my 3 little boys. And the middle one, Elijah, is 6 now. But that's Elijah in the picture to the left, because he was born with a very rare heart condition. And we didn't know that until he was a month old. And my wife was rushing him to urgent care and then immediately told when she showed up to urgent care, his heart rate's over 230 beats a minute. His blood oxygen is so low, I don't know how he's still alive. We got to get you to Children's Hospital. We have no idea how to deal with him. You got to figure out what's wrong, because we didn't know. And the doctors didn't know who had treated him for the first 6 weeks of his life. Someday, I get to have a conversation with my son to say, you're 18. You're going to go off into the world and go follow your plan. But you need to make sure that you have a healthcare power of attorney at a bare minimum. Why? Because you might go into SVT and somebody's going to need to tell a doctor what to do or not do. And you probably need to have your mama do it, because dad liked to be really good, but I was bawling my eyes out not knowing what to do on an emergency room floor because I thought my son was going to die. So understand that that just puts a little bit of a sharp, fine point on it. People need to have their planning in place because you don't know what tomorrow is. There are no promises, and it is guaranteed to no one. So get it done, put it behind you. Remember that this lawyer speaks from all of the bad experiences that he has, not necessarily from the good experiences, and then you can get back to living your good life. Someday I'll also get to talk to these boys about throwing Hot Wheels back and forth in front of each other and how that's not an effective way to transfer Hot Wheels to each other. Questions? Any other questions? Yes, sir.
I have a question.
Yep.
About the revocable trust.
Yes.
And do you need a will with the revocable trust? Do they interact with one another,
So-
or one or the other?
Yeah, so the question is, do you need a will with a revocable trust? And I would tell you, yes, I think you do. It's a specific kind of will. It's called a pour-over will. And it's meant to be, we anticipate that the assets that you put into the trust or that you direct to your trust are going to get there and then be distributable. But sometimes mistakes happen. Oopses happen. And if we ever need to use the court system in order to distribute an asset where we don't know for sure where it's supposed to go, the will, the pour over will says, well, take that oops, the mistake, and pour it over into our trust, because that's the most clear intention of what we intend, who we intend to benefit if we didn't state it somewhere else. So it's a real basic version. I know people will tell you, we don't need the will at that point. And I said, that's great, as long as there are no mistakes. But again, I have job security because mistakes happen all the time.
Just one follow-up.
Yep.
Does the pour-over will subject to probate or?
So the pour-over will is subject to probate because we do need court supervision for that type of mistake. And oftentimes it's a pretty serious mistake. It's something that was not intended. So Yes, the poor question was, is the poor will subject to probate court? Yes, it is. But we need that system in order to ensure that we transfer whatever that mistake asset is to the correct vehicle to distribute it at that point. Other questions?
So I have a question here in the chat, and anyone online, the webinar, feel free to ask a question or put it in the chat. But the question is, do custodians need social security numbers too? I believe the children do, uniform transfer to minors, children do, but I don't believe the custodian does in our beneficiary forms. I don't believe we put the custodian social security number.
Correct. We'll be able to figure out who the custodian is through usually just the document itself. We don't necessarily need to know how the government identifies the custodian, because remember, the asset's not for the benefit of the custodian. They're just the placeholder to make sure those assets are managed correctly, very much like an agent under a financial power of attorney. But we do need to know who the beneficiary is, and the only way the government knows is to find their social security number.
Nope.
There will be a custodian. It's preferred that you name this custodian. So you can name your custodian, and Carly, you can probably jump in. You have a specific place on your forms to actually name the custodian?
Well, we do, the way we word it. So on our IRAs, Roths, individual Schwab accounts, transfer on death. So we'll have a primary beneficiary. Usually it's the spouse, but otherwise, if it's children under the age of 18 or handicapped children, you would put a custodian. So what we do is we put Jane Smith, custodian for the benefit of Jimmy and Susie, social security number, date of birth under the Uniform Transfer to Minors Account Act of the state.
Sure. And it would be very typical if you don't name them on the form provided by whomever the financial account holder is. If you can't put it on the form, the statutes are very specific. You can put it into your estate planning documents. And I don't do this for every client, but there are specific clients who intentionally intend to benefit very young people, and they're very not young. When I have a discussion with a 95-year-old who wants to name some great grandchildren who are 2 and 3 and 5, well, statistically, you will not be here when they turn 18. So I will put that information into her estate planning documents and say, then if you don't name a custodian on the form, if they're going to be a beneficiary, then the custodian is whom? Typically their parent who's biologically related to the decedent as well.
Okay, maybe I should make it a little more specific. I have
Yes.
2 adult children that are
Mhm.
30 and 27, so
Mhm.
why do I?
Oh, you don't need it for them. And they're not subject. So would you, so the question is, what if they're above the age of 21, meaning where the custodian rules don't apply? Well, my hope is that they're old enough to receive it outright at this point. Not everybody's 27 and 30-year-old are ready to deal with their own money, though. So oftentimes the planning in that case would be a trust that continues for their benefit from their share of assets, whatever that might be. And then it would often be managed by someone else as well. So in my planning, my revocable trust planning right now with my wife, hey, here's this potentiality. I die first. I'm going to pick on husbands. I'm going to pick on men. And we just got through Father's Day. So if you're a father, you got it all out yesterday. Today's the day we're back to reality. We die first. Fine. Everything to my wife. But if she and I both die, or she dies first and I don't change my planning, my backup planning is that it stays in trust for our kids for a very long time, even as far out as 40 years old. Why? If my wife and I are not here to parent them, they have a long way to go to grow up. And I hope they reach maturity like we're supposed to, but that's not a guarantee any longer. And I'm not so sure 18, 25. Is an 18-year-old the same as when you were 18?
Changed because my original one, I had a custodian when my children were much younger.
Much
but
younger.
Now they're 27 and 30 and
Correct.
they are very independent and they can handle it.
Good. Well, that's the good.
So then
See, these are the stories I don't get. So the comment was basically now that they're older, obviously you had custodian provisions before, you probably had guardian provisions for them, you know, if they were a minor child still. So all the planning that you need to for young people. But when they get older, well, what are the thoughts at that? My hope is that they can be direct beneficiaries. They can receive the direct payment of whatever is there for them. Not everybody can. And so the normal thought process is, well, if they can't, how much longer? Who's still going to be in charge? And then what vehicle are we going to use to still help manage their money for their benefit long into the future? I have a client of mine. They have one child and he is the most wonderful child I have ever met. And his parents' planning is to put all of his funds, which is a significant chunk of money as an only child, lifetime trust. Like, are you kidding me? This boy is going to be one of the most successful people that I'll probably ever know, my children included. He does not need to have his money tied up in trust for the rest of his life. Well, you do yours till 40. Well, yeah, because I hope to see them, you know, turn 40. That's the emergency plan. You guys are set on that this kid's going to have his money held in trust forever. He doesn't need it. He's already at 16, same age as my oldest. If that kid came up with an idea, I would 100% be investing in it. How much money can I put into your pocket? Because he comes up with all kinds of great ideas all the time. And he is a doer and a builder. That kid's going to make something amazing. So again, it's the evaluation of what's appropriate in your scenario. Any other questions from the audience? Questions online, Carla?
No more, but you know, we always talk about wills. Wills are good, but it's a direction right to probate, right? Wills will direct you right to probate. So direct beneficiaries on your accounts, you can even do transfer on deaths on property. But trust, if you want to control more with your estates and your, you know, if you have maybe additional beneficiaries or you have different trustees or you want to just control more of the assets, that's where a trust would come into play.
And I would agree. Sometimes you can't prevent going to court, going to probate, but oftentimes you can. Again, my horror stories are gleaned from, you know, just a lot of years of in the trenches legal work, and understand that's where the sort of concern or where my thought process is. You know, if I could avoid probate court, I would absolutely. It can't be avoided all the time, and sometimes maybe it's the right place to go, but ultimately there are a lot easier paths. There's a much more efficient way than to chuck your Hot Wheels into the probate court system and see what comes out the other side. Oftentimes when I go to probate court and becomes a contested matter, if we could have avoided it, that would have been great, because as soon as it becomes contested, just the legal fees go through the roof at that point. And oftentimes legal fees get paid out of the decedent's assets, out of the pot, not necessarily out of people's pockets, even though that's the way it should be. Because they come to agreements, because eventually, when I see the litigation, eventually people just give up after a while because they realize, well, I'm not going to get anything and the lawyers are going to get everything. So I better stop now. Well, then that's usually when people, well, I'm going to give up some in order to pay my lawyer because I didn't realize they would have a $137,000 legal bill. Yeah, it gets nuts fast. So I would encourage you, if you have the right planning tools and can avoid the probate system, you don't need it, don't use it. I mean, it's like the Department of Public Works. Hopefully my pipes don't break and then there's a huge sinkhole in my front yard. If they do, I guess I'll have to use them and be uncomfortable. But if not, I'm not going down to the Department of Public Works to go talk to them and bother them about my water. Yeah, I don't want to talk to you if I don't have to. So, any other questions? If not, you can find me at the corner of 88th and National in West Dallas. It's a sleepy little law office that looks like a little ranch single-family house. Business has been in existence for almost 120 years. my partners who are all brothers hope that it's there for another 120 afterwards. So my hope is that maybe a couple of their or a couple of their nieces, nephews will become lawyers. Maybe it's great nieces and great nephews at this point, become lawyers, because we could use a few more out there. Thank you,
So-
Carla.
You're welcome. And Nathan,
Yep.
you've been wonderful. Thank you for your sense
Sure.
of humor. And this is a topic that's kind of sticky and tricky and changes, right? These change a lot. This would be important for everyone to review their beneficiaries, review your assets, review how you want them. Things change in life. And again, like you said, we don't know what tomorrow brings, so make sure, once those kids are 18, there's powers of attorney, power of healthcare. Those are all important pieces to have for kids. And in Minnesota, we have a few attorneys, because you work primarily in Wisconsin, right, Nathan?
Primarily in Wisconsin, although I do have some clients who are border hoppers still into Illinois, and I still do their planning for them.
Got it. And we have additional attorneys that we work with up in Minnesota. So we appreciate your work, your help in your webinar today, Nathan. Thank you.
Sure.
And we thank all the advisors that invited people to today's webinar. We have a wonderful group of advisors, so reach out to your advisor for additional questions that you may have. Thank you.
If you have